Madam Clerk, please open court.
The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. Welcome to the Supreme Court of North Carolina. The court calls 314P20 N.C. Bowling Proprietors Association versus Cooper.
Thank you, Madam Chief Justice, and may it please the court. I'm Ryan Park from the North Carolina Department of Justice, and I'm here representing Governor Roy Cooper. If I may, I'd like to reserve 5 minutes for rebuttal.
You may.
This case concerns the legal standards that apply to review temporary emergency measures that are designed to slow the spread of a deadly and incredibly infectious virus that has precipitated the greatest public health crisis that our state and our nation have faced in over a century. But while the pandemic might be unprecedented in many ways, the legal standards that apply during a public health emergency are not. Since at least the great smallpox vaccination debates at the turn of the 19th to the 20th centuries, courts have almost uniformly held that public health policies to curb the spread of a, quote, deadly pestilence warrant a uniquely broad level of deference. In our state, this doctrine traces back to 1900 in State versus Hay, where this court upheld a mandatory smallpox vaccination regime on the ground that decisions on public health policies of such gravity are for the policy-making branches of government to make, and not for courts. The court emphasized that courts are institutionally ill-suited to judge whether a particular public health measure is appropriate, because courts merely, quote, construe and apply the law. They do not set policy. And if people wish to rebalance the often difficult trade-offs between protecting against a grave public health hazard and economic activity, they have the power to elect new political leaders that will do so. Or as the U.S. Supreme Court famously held in Jacobson versus Massachusetts, citing this court's own decision in Hay, quote, courts and juries are not the proper arbiters of public health policies, and it would, quote, usurp the functions of another branch of government if a court were to adjudge that the mode adopted to protect the people from a deadly disease was arbitrary. And
Are you arguing that the power of the governor is the same as that of the legislature? In other words, I believe the case that you cite was legislative authority, not the unilateral action of a governor. If you are arguing that the governor has the same authority and his actions should be reviewed with the way that we look at an act of the General Assembly, how long are you arguing that that power would last?
Thank you, Your Honor. So there are two parts to that question. So on the first part, absolutely not. We are not asking for the level of deference that would be accorded to, for the governor's unilateral actions, that would be accorded to the legislative enactment. But here, the governor has not relied on his inherent constitutional authority. He's relying on the delegated authority from the legislature in the Emergency Management Act. And that's the exact same situation that the court was presented with in Hay. It was a delegated grant of authority to a local government from the General Assembly. And the court held that as long as that legislative delegation was valid, then the same level of deference is afforded to a body who exercises delegated authority. And so on that first question, you know, if the governor were acting outside the bounds of his statutory authority, we concede this would be a very different case. But that's not the case here. And on the durational issue, which is very important, I would say that if you look at the Emergency Management Act, the legislature made the considered decision to give the governor the unilateral authority to determine when an emergency has ceased. So that's in section 1920 of the Emergency Management Act. And there's a very reasonable reason for that. And that's because many emergencies, like a pandemic, will last for a long time. So if there were a nuclear meltdown, 20 miles south of here, there's a nuclear reactor in Wake County. If there were a nuclear meltdown, the emergency that would spark would last for a long time, far longer than 6 months. And so I think the legislature made a very reasonable determination that it's not going to set a time limit on the extent of delegated authority.
What is, Mr. Park, what's the difference then between the standard of review applicable in an emergency situation and the ordinary standard of review that y'all debated at length in your briefs?
So I think that it's not entirely clear in this court's cases because the emergencies of this kind don't arise.
Well, what's your best guess as to what you think it is now, and how does it differ? And what basically trying to figure out is what is the standard? I know you're making a two-part argument. One, I went under the standard that we think applies in emergencies, and secondly, I went in case you apply the regular one. I'm just trying to figure out what's the difference.
Yes, exactly, Your Honor. And I think that the best read of the cases is that an additional layer of deference is applied to whatever the standard of review ordinarily might be. So I think the South Bay decision from the U.S. Supreme Court is instructive. So, there is obviously a free exercise test that applies generally on claims of that kind. It was a religious freedom case. But what the court did is it added an extra layer of deference when applying that test. And so we say that the rational basis test applies to the underlying claims here. And I think what happens during a public health emergency is that what is considered rational is given an extra degree of latitude. And so, in times of uncertainty, for example, right now, standing here before you today, there is no consensus on how deadly this disease is, on whether how it spreads, even whether if you're infected and then recover, if you're going to have long-term health outcomes, or you're going to have immunity, and for how long you're going to have immunity. So in this context of such extreme uncertainty, then there's an extra layer of deference that is added to measuring whether the governor's actions are rational.
Well, if the regular test, and I mean, I've read all the cases and the marginal differences in how you phrase it, but it appears to be, does it bear reasonable relation to an important governmental purpose? The word necessary shows up a couple of times. Sometimes we add words to rational, but that appears to be the basic formulation. If you were to formulate a test applicable in an emergency situation, what is it?
So I would say that you take the existing claim, which we think is rational basis review, and then you add deference on top of it. So the court's evaluation of what is rational has to have an additional layer of deference. And so, if you read all these cases, and there are a lot of them, there are a lot of different fact-specific applications of what the court considers rational. And in an emergency, the court has to say, we have to have an even stronger presumption that the emergency measure at issue was reasonable and did not. Yes, Your Honor.
Mr. Park.
The Boland folks here appear not to question the authority of the governor. This is an equal protection claim. Would you agree that, let's say you had two restaurants side by side, that the governor can't open one restaurant and yet close the adjacent restaurant? The governor can't be arbitrary with regard to that. You would agree with that, wouldn't you?
Well, so it's difficult in a hypothetical scenario. And I apologize, Your Honor, because I'm not a public health expert. If there were a meaningful public health rationale.
Everything is equal. Everything is equal. I mean, I'm trying to figure out the how far you think that this deference should go. So I've got, my hypothetical, everything is equal, other than the governor picks one restaurant that can open, but the other one cannot.
I think that if you're talking about similarly situated entities like different restaurants, if the governor said, every restaurant with an odd numbered address, it must close, that would be arbitrary, I think, under any standard.
Well, it seems to me that the business court has said that the governor failed to present any evidence which distinguishes the bowling alleys from, say, indoor swimming or some of the other activities that the governor has authorized that could be open. What evidence that was presented to the trial court do you believe was overlooked or mischaracterized by the trial court in determining that the bowling alleys were treated differently than other similarly situated businesses?
Thank you, Your Honor. And I agree there's a lot of confusion in the record on this point, and I'm eager to answer the question. So I think the baseline assumption of the trial court's order was that the proposal of safety protocols by an industry association, warrants a different level of scrutiny. But I think the critical factual error in that is that, safety protocol, there's no venue in the state of North Carolina and in most of the country that is allowed to operate without safety protocols of equivalent kind. That is the baseline minimum presumption upon which the public health authorities are allowing certain venues, high-risk venues, to open. And so, of course, when the Phase 2 order came out, or when Secretary Cohen issued her declaration, that was the comparator was, whether bowling alleys, bars, gyms would be safe or sufficiently safe at that time in the pandemic to open with safety protocols. And in Phase 2, there are extensive safety protocols that are applied to restaurants, and so her declaration, where she talked about pools, and she said, pools are relatively more safe because they bathe in chlorinated water. Chlorine is an incredibly powerful disinfectant. It's the active ingredient in bleach, and so we think, using our common sense public health expertise, that that's relatively safer than bowling alleys. And that was and again the comparison that Secretary Cohen was working against was bowling alleys under extensive safety protocols.
Do you agree with the trial court that once the bowling alleys presented their extensive safety protocols, that the governor needed to respond to those protocols to indicate how they were deficient?
So, Your Honor, there's a legal response and a factual response, and the answer on both perspectives is no. So, from a factual perspective, it's the same response I had earlier, which is the Secretary Cohen's, the Governor Cooper's, analysis of those protocols had already taken place. The Phase 2 order and Secretary Cohen's declaration, which is 308 pages with exhibits, and it specifically said that under protocols that are equivalent to what has been proposed, and my understanding is that their evaluation of bowling alleys and similar indoor entertainment venues would involve greater safety protocols than what they proposed. Those were all already responsive to that point. But as a legal matter, I think that that's simply not how rational basis review works. And so we're back to the question of, what is the standard of review? The court's cases are legion.
Before you move on from that, Mr. Park, I mean, it seems to me this is one of the questions that we need to think about. Is it your contention that that the court should require or should hold that the governor in determining economy-wide restrictions is permitted to look at sectors of the economy, or is the governor required to focus on each specific industry?
So I don't think that the fruits of the labor clause requires the governor to take either approach. I think he has discretion to take the approach that his public health experts advise is most appropriate. And I think one thing just to keep in mind in the background is, of course, every industry that is subject to restrictions has proposed safety protocols. For example, in the Tallywhacker case, this is in federal court, but the adult dancing industry submitted protocols that were very extensive, more extensive than the Bowling Association's protocols. And the court and the governor all agreed that those were not sufficient at this point in the pandemic to allow for the additional risk that would be entailed if adult dancing establishments were open.
One of the things I've been thinking about is that it seems to me the trial court's order essentially focuses upon bowling alleys, or I gather they prefer to be referred to as bowling centers, and I'll probably use them interchangeably. You have to look at everything the trial court's order looks at bowling alleys or bowling centers in isolation. Is that your read of the order?
I agree with that reading of the order.
To what extent do you interpret the trial court's order to say that in each specific industry, if that industry comes forward and proposes a set of voluntary restrictions, what is your understanding of what the trial court's order requires the government to do with that?
My understanding is that if advising a client reading that order, I think you would have to say that based on what the trial court believes are similarly situated entities, if there are a set of standard safety protocols that can be adapted to any setting, that if those protocols are proposed, then they're presumptively valid. And I think this really highlights the institutional, relative lack of capacity that courts have to manage these kinds of issues. I mean, the governor is advised by more than 40 public health experts who are working full time. These are people with PhDs in public health, they're medical doctors, and they are looking at the economy as a whole, trying to mitigate aggregate risk. And so they're thinking about public schools, they're thinking about restaurants, they're thinking about entertainment venues, and they're thinking about how can we keep risk under a certain level where we don't overtax hospitals, where we don't have rapid surges in infections that lead to unmitigated spread of the virus. And that's a fundamentally policymaking enterprise. It's not one that courts that look at case by case. Here's bowling alleys, here's trampoline parks, here's bars, and I'm going to look at this one industry in isolation. It's simply not how public health policy is made.
Is a governor in implementing a statute like the one that we have here entitled to consider his or her view of the societal benefit of each particular industry or each particular segment, and if so, why or why not?
I think that this is, again, where I think that deference would kick in. I think that a court wouldn't be, I think, within its lane to, construe and apply the law if it determined that, I think that bowling is based on, a declaration that was submitted to me is more valuable than trampoline parks. And so I will allow bowling alleys to open and not trampoline parks. I think that's a quintessentially policy decision. And so the governor, as he has said, repeatedly in public, that, his priority is opening up the public schools for in-person classroom instruction, allowing that to happen. And so, he made a choice to continue more stringent restrictions on entertainment centers to try to allow the best chance for that to happen. And I think that kind of dimmer switch approach and deciding which sectors of society are higher priority was for the governor to make, and not for the courts.
From a precedential standpoint, for this court's purposes, are you relying more on our decision in State versus Dobbins in terms of the governor's exercise of the emergency powers of the governor, or relying more on Poor Richards as a decision that this court has made concerning the operation by the governor outside of emergency powers, but based upon business considerations or some hybrid of both of them?
So I think both of them, Your Honor. I think the best way to look at how the emergency standard and the ordinary standard of review interact is it's kind of like a standard review, clear, convincing evidence, reasonable suspicion, that filters through an underlying ultimate inquiry. So, here, as I was discussing with Justice Ervin, I think that you're looking first at the Poor Richards standard. Is it rational? And then you add a heightened level of deference because it is an emergency situation. And I think most public health observers agree that this is not just any emergency. It is an existential emergency that hasn't arisen in our country in over 100 years. And so that an extra layer of deference, even beyond, a riot that might happen in a city over a period of a couple days.
The Bowling Association looks at it actually on the reverse side of that coin and says that there should be less deference given under these circumstances, and that the reasonable relationship test that the trial court applied should be the one that we look to for guidance. Why doesn't that type of analysis work?
So I think the fundamental problem with that analysis is it placed the burden on the governor to come up with evidence to show why the bowling associates and proposed protocols were not as safe as, or did not, satisfy the government's interests. And that is simply not how rational basis works. In case after case, this court has said, and Proprietors itself, it said the state is not required to come forward with evidence. It said, if facts are necessary to render an economic regulation valid, the court will presume the existence of those facts if they're reasonable. That is directly from Proprietors. And so I think it's really a matter of who has to prove that the measure was valid or invalid. Is it the governor or is it the bowling association? And I think that's the critical problem with the lower court's analysis.
So many of our cases and many of the ones you rely on are regulatory actions or regulatory with regard to industries as opposed to a complete shutdown. Should we look at things differently when there's a fundamental right to the fruits of your own labor, and yet the governor's action is not regulating, it is a complete shutdown of that segment?
So I think I would, quibble with the premise of the question, and here I think we'll be on the same plane, which is that these are temporary measures, and so they're not a complete shutdown. There are cases where, yes, Your Honor.
What temporary? Define that for me. Is that a year? Is that 2 years? 5 years? Is it 10 years? What is temporary?
The order that we are discussing today lasts 5 weeks. Until September 11th. And I think, if I may, I'd like to be able to address an issue that has been hovering over these proceedings but never explicitly briefed, which is that at some point, I hope very soon, we all hope very soon, that the public health metrics allow the governor and his public health experts to say that the state can absorb the risk of opening bowling alleys and similar facilities. And I think it's likely that that will happen soon. The governor yesterday, I don't know if the court saw, announced that even today he's going to be announcing how the next phase of the plan is going to operate. And my understanding is that whenever we do move to the next phase, bowling alleys will be among the next tranche of cases of venues that will be allowed to open. So I'm sorry, but the answer is I don't know how long it will last. I think it depends on an evolving situation, there is a stable set of risk factors that bowling alleys present, but the larger question is how our state is doing generally in response to the pandemic.
Sorry, if I may just follow up on the point you just made about the potential for the governor to lift this order and open bowling alleys. At that point, does this appeal of the preliminary injunction become moot?
So I think it potentially becomes technically moot, but this court's, of course, mootness under this state court's cases is not jurisdictional, and the court enjoys the discretion to consider technically moot legal issues if the public interest so demands. And just a couple months ago, as I'm sure the court is aware, in the Chavez case, the court articulated a very helpful rubric for analyzing questions of this kind. The first is this something that is subject to great public debate? I think we'd all agree that this might be, one of the defining issues of the pandemic, and that the pandemic response is the greatest public policy issue that we're at least facing at this moment. So I think it would easily, meet that standard. The second is, whether this is capable of repetition or it's, and the answer is, of course it is. I do not have full insight into the phase reopening plan, but at the next phase, some restrictions will certainly continue on businesses, perhaps not bowling alleys. And we are managing, almost 20 cases from various business entities raising similar claims, and many of those claims will survive. And so I think it's incumbent upon this court for the public interest, to delineate the proper line between policymaking and judicial review in this situation. It's going to recur again, and I guess the final point I would say is that even as applied to bowling alleys, that if conditions require, the governor it's not like the ordinary situation where a government actor moots a case by withdrawing a challenge policy. We're not saying that we agree this is a problem constitutionally, or that we're not going to reimpose it. We're actually saying the opposite, that we pledge to reimpose it if it's necessary to reduce the spread of infections.
Mr. Park, I'm sorry to interrupt you, but I've got a quick question. You said that the key for the court is to delineate the line between policymaking and the exercise of the governor's discretion. How would you articulate where the state thinks that, or the governor believes that line should be drawn, or how we could describe that? Because that it does seem to be the key here.
Yeah. Yeah, so if I were to describe it in one sentence, it would be as follows, that during a public health emergency, the policymaking branches of government can enact policies that are reasonable, and that the measure of reasonableness is accorded a due deference. And that would be the standard that we think applies here. For me, I'd like to reserve the remaining. Oh, sorry, go ahead, Your Honor.
No, that's okay. Go ahead.
You wish to reserve the rest of your time, Mr. Park?
Yes, Your Honor.
All right.
Thank you.
Mr. Biller?
Mr. Miller, you're on mute.
I believe I've now been unmuted. Thank you, Your Honors. Good morning. My name is Anthony Biller. I'm a member of the Wake County Bar, and through my client, the Bowling Proprietors Association of the Carolinas and Georgia, I represent the interests of 75 North Carolina bowling centers, their employees, and the many working families that frequent these establishments, some of which establishments are old and some of which are new. All of the lanes are closely held. Some of them are brand new, state-of-the-art, family-friendly entertainment centers involving investors from around the country, to include at least one multi-million-dollar center that was under construction and has not yet been allowed to open. Some of my clients are multi-generational family affairs where owners operate lanes built by their grandparents many decades ago, and where the owners eat around their dinner table each night and train their children how to operate cash registers and clean equipment. Your Honors, thousands of North Carolinians are tuned into today's hearings and this court's decision. This decision affects the livelihoods and families of thousands of North Carolinians. COVID-19 was contracted in the United States, first diagnosed in Washington State in January of this year, 9 months ago. Governor Cooper declared a state of emergency on March 10, 2020, 175 days ago. He still rules unilaterally under powers he claims pursuant to the Emergency Management Act. 162 days ago, Governor Roy Cooper ordered most industries closed and ordered North Carolinians to stay in their homes. And since then, Governor Cooper has lifted his general ban on North Carolinians leaving their homes, and he has lifted his ban on most industries. Today, Governor Cooper has drawn lines to allow North Carolinians to get tattoos, to send their children to overnight indoor camps at the YMCA, to drink beer indoors at breweries, to eat at indoor restaurants, to play intense basketball games and youth soccer matches, to congregate in indoor food halls, to engage in mass protests, to enjoy social hour at the Raleigh Country Club. Governor Cooper does not, however, allow North Carolinian bowling centers to open their lanes. My clients have been deprived of their livelihoods for going on 6 months. Regardless of how one feels about COVID-19, there is not a single study associating bowling with COVID-19 outbreaks, despite bowling taking place continually without interruption this year in at least 7 states, and despite dozens of other states resuming bowling since May. There is not even a single reported anecdote of bowling associated with any outbreak cluster. There has not been a single opinion rendered in this case or otherwise why my client's COVID-19 safety standards promulgated in May of this year and found in the records at pages 38 through 54 are in any way deficient for protecting public safety. To the contrary, the safety of bowling has been proven in the dozens of states that permit bowling. As of today, 48 other states allow bowling. Only
Mr. Biller, I'm sorry to interrupt you, but as I understand Mr. Park's argument, it is that the relative safety issues involving bowling centers have been taken into account in the governor's exercise of his discretion to enter the order, and that they're presumed to be effective. Why isn't that a question for the health professionals and to be analyzed under the governor's exercise of emergency discretion?
I'm sorry, Your Honor. I believe you said that Mr. Park said the Bowling Association safety standards have been taken into account. If they have, and I don't doubt that Mr. Park's integrity, there is nothing whatsoever in the record reflecting that. In fact, the governor's attorney was asked repeatedly by Judge Gale, what distinguishes these bowling centers operated pursuant to these safety standards from other establishments, such as brewery tap rooms that the governor allows to operate. And repeatedly, the governor had no answer. So, Your Honor, respectfully, if there has been an assessment of those standards and why those standards justify distinguishing bowling alleys from operations that are allowed to operate, those have not been shared with my client nor with the trial court.
Well, my understanding, and I could be misunderstanding the argument, but my understanding is that Mr. Park cited case law for the fact that the protocols are presumed, or that the mitigation is presumed to be effective, and that decision is to be weighed by the governor in the exercise of his discretion, not to be second guessed by the court unless it is beyond the appropriate exercise of that discretion under the appropriate standard of review, however we decide that is.
My colleague did say that, Your Honor, and that is not what Poor Richard says. Poor Richard says if there is no evidence to the contrary, we can treat the representations on the first prong of the analysis as being rationally related, if in fact they are. That's what that case states. It does not state that the governor is required to A, come forward with no reason, which is the case we have here, or B, if challenged, doesn't have to substantiate those. And it's important because Poor Richards weaved together and culminated 100 years of this court's precedent. And the Poor Richards test should be, in answer, I believe it was Justice Irvin's question, should be the test that's applicable at any time a fundamental right, such as the rights found in this case, are at issue.
Mr. Biller, let's talk practicalities here a second, just so I'll understand if we were to accept your argument where we wind up. Essentially the trial court appears to have accepted what I gather was your contention before the trial court, that the association was entitled to present proposed safety standards that mitigated the risk that were said to be concerns in Secretary Cohen's affidavit. And that since the governor did not come forward with specific evidence, and I understand you're not saying that it had to be like peer-reviewed data studies, but that the governor's failure to come forward with such evidence meant that the restriction as applied to your client was unconstitutional. I mean, is that a fair characterization both of your position and the trial court's holding?
I believe it is, Your Honor. Put it in a slightly different way. My colleague has said that this court should not hold the governor to a strict evidentiary test when he draws lines regarding who he allows to conduct business and who he has ordered shut for 6 months. It's more than
Let me go on a second and apologize for interrupting you, but I'm not smart enough to retain my train of thought very long. It looks to me as if the trial court's order focused solely on bowling centers as bowling centers. Is that also fair?
Within that, Your Honor, it focused only on bowling centers whose normal operations were conducted pursuant to the safety standards submitted to the trial court.
Which would be, in essence, the members of the association?
Yes, Your Honor.
Are there bowling centers that don't belong to the association?
There are some, yes, Your Honor.
Under the trial court's order, are they allowed to open?
If the trial court's order effectively adopts the meat of the association's safety protocols, so any bowling center, regardless of whether they were a member of my client's association, that abided by those safety protocols would be allowed to operate. I mean, it's a very detailed order.
I mean, I've read them, and you've got limited time. I'm sure my colleagues have other questions, and we've read those. Is every single type of business in the state entitled to assert the same claim that you have?
Every single business in this, yes, Your Honor. Every single business in this state is entitled to assert its fundamental right to enjoy the fruits of its labors, and every single business, just like every individual in this state, has the fundamental right to equal protection under our Constitution.
Okay. So that in essence, I mean, what I'm concerned about is just the practicality of the trial court effectively being required to analyze on an industry by industry basis, not even a segment like you just said. Some of the findings tend to categorize your clients as a part of a broader category of entertainment centers, for example. But I don't read the trial court's order as addressing entertainment centers as a broader category, but rather bowling centers only. Would acceptance of the approach adopted in the trial court's order effectively require Judge Gale or somebody like Judge Gale to review safety protocols for every industry in the state?
I don't think so. Not
Why not? Why not?
Well, answer that in two parts, Your Honor. Judge Gale did not second guess the governor's critique of those safety standards. He simply asked the governor what is wrong with these safety standards. Now, if we look to the parallel place where he tried to distinguish, in fact, did distinguish why the governor allows beer bars to operate, but regular bars to not operate, he asked the same question. And in that case, the governor came forward and had anecdotal evidence of outbreak clusters around bars. In fact, they filed the same evidence in our case as they did in the bar case. If you look at the evidence that Secretary Cohen appended to her declaration, it's predominantly, or it's weighted very heavily towards the evidence of outbreak clusters associated with bars. And in her opinion, Secretary Cohen said, I think the social norms within bars are different than the social norms within beer bars, and the social distancing are less likely to be observed in a regular bar than in a brewery tap room. And Judge Gale said, that's rational. That makes sense. Motion denied. Now, the problem we have, to your point, Your Honor, nobody has required the governor to slice up the winners and losers in this economy. The problem is when the government comes forward, in this case, the governor acting pursuant to an emergency power, acting on behalf of all the municipalities and all the counties of the state, and he decides to slice up the economy from from Murphy to Manteo, and treat all businesses the same, and then start dissecting them and picking the winners and losers. That was the governor's choice. And once he starts picking winners and losers in a way that fundamentally affects the rights of North Carolinians, that shuts down businesses for months at a time, the onus is on the governor for demonstrating his rationale for infringing upon the fundamental rights of some North Carolinians in favor of other North Carolinians. And if he cannot do this, this court's case law is very clear, and so is the cases in the other jurisdictions. Now that the governor loves—
Let me stop you for just a second. Do you read the Bar and Tavern order as requiring the governor to carry the same burden of proof in the court as your asking here?
It is the same. It is exactly the same. In fact, Judge Gale said I'm adopting the same standard that I had in the bar versus brewery taproom case.
And what authority do you think is the strongest authority for, in case law that you just mentioned, there was case law to require the governor to satisfy a burden of proof in a court of law in exercising his emergency powers under the Emergency Management Act?
Yeah, well, I don't think that our constitutional rights, the calculus for this court's assessment of fundamental rights under our Constitution changes or should change. And I don't think there's anything in precedent saying whether somebody raises the prospect of emergency or war or famine or any other exigent or serious conditions. The calculus is the same. And I think this court did an excellent job in Poor Richards of laying down the two prongs that this.
So are you saying it does not make any difference for our purposes today whether there is an emergency or not?
Of course it does. The calculus is the same. The calculus.
I'm having trouble getting the distinction, again, perhaps due to my limited mentality. But
Your Honor, if you would allow me to, I would be happy to explain it. The fundamental rights don't change over time. The Hayes decision, Justice Douglas's concurrence in there. So these are inherent, timeless, fundamental rights. The analysis of the government's interest, the calculus this court established for evaluating the deprivation, in this case, the total prolonged deprivation, does not change. Does that mean that whether there are emergency standards or emergency circumstances in place is irrelevant? Of course not. This court's decision was not poorly thought out. If you look at Poor Richards, there are two prongs. The first prong in evaluating, and they go through the better part of a century worth of precedent. The first, is there a proper purpose? Prior courts and like Shreants will say, is the government's purpose, is the evil sought to be remedied rationally related to the group that's being regulated? That's the first prong. Now that prong, the rational relationship between the group regulated and the harm sought to be prevented, should always be asked. Now, the second prong gets to, Justice Erwin, your concerns. Well, what was the second prong? Is this a reasonable implementation? And this is where Judge Gale nailed it. What is reasonable on day 16 of an emergency is not necessarily the same as what is reasonable 162 days later. Reasonableness comes up over and over again. In the Dobbins case referred to by Justice Morgan, the court goes well into the evidence, and it covers very quickly multiple constitutional and statutory challenges. But the inquiry is the same, though not articulated nearly as well as this court articulated it in Poor Richards. Is this reasonable? Is this right?
Mr. Biller, I have a question for you. If the association had not proposed these additional safeguards, would you concede that the governor would have the authority to require the continued closure of these bowling centers?
I would concede, Your Honor, that Secretary Cohen would have satisfied the first prong of the Poor Richards analysis. And that is, are these regulations reasonably, or are they rational or proper given the harm that sought to be prevented? And we have taken issue, but I don't think it's a hill worth dying on, that this disease is extremely deadly for people over 65 years of age, with, the CDC said on Thursday, with an average of 2.6 additional comorbidity factors. I mean, those simply are not the people that are found in bowling lanes. That would be relevant to this first prong. Is this regulation what we're trying to prevent here? And this is death by COVID. Is it reasonably related to activities or rationally related to activities within bowling lanes? If you say that the rational government, the reasonable government purpose is preventing the congregation of people to slow down the spread of the disease, then Secretary Cohen, if there were no social standards in place, no COVID standards in place for the association, then I think Secretary Cohen's explication of why the general nature of bowling lanes would satisfy that first prong. But this court would still be facing the second prong. Unlike the case that my colleague has cited,
Let me ask you a quick question. Let me ask you just a real quick question. Did Poor Richards involve the exercise of powers under the Emergency Act?
No, it did not. But
what difference do you think that makes, if any?
It is a factor that needs to be weighed in on the reasonableness once we get to prong two. In assessing the constitutional deprivation, is it reasonable? And what we find over and over again is the greater the deprivation, that is, the more the fundamental right is affected. In Poor Richards, it's regulated. In fact, this court said in Poor Richards and said in Dobbins, this is a very modest imposition on your fundamental rights. In Hayes, it was a temporary inoculation to address a disease that killed 30 million people, or 300 million people, had a fatality rate, according to Hayes, of 30% of people that contracted smallpox died. Is this imposition on your fundamental rights reasonable? And the greater the imposition, that is, the greater of the taking away of the fundamental right, and the longer that taking away goes, the less likely we are to find courts upholding the ordinance or the declaration at play.
You would agree, let me just ask a follow-up. You would agree that the purpose of giving the governor additional powers in an emergency is to enhance his ability to act and act quickly in the event of an emergency affecting the population, wouldn't you?
Yeah, certainly. And I think the very definition of an emergency is something that happens unexpectedly and for which we were unprepared. The courts in North Carolina have refused to entertain challenges that were 9 months into this pandemic.
The act provides that those emergency powers end when the emergency ends.
But this court has not yet, and we are not in what's before you, Your Honor. We are not challenging the governor's power to pass these orders.
Yes, you're in the right place. I just forgot to start the practice session when I first started. It's so that as everybody's getting in, the only people who can see and hear are those of us who are panelists.
I'm going to pause the.
So you are in the right place, and you're all set.
We're having an audio issue, I think.
Well, I think we'll mute ourselves until John Sabat gets on. Okay.
Sounds good.
I think we're being fed the practice session for the next.
I think
that's exactly what it is. You may continue, Mr. Biller.
Thank you, Your Honor. So Justice Hudson, before you today, we do have a claim that challenges the constitutionality of 166A-1930C, the power to which we reference, as applied 9 months into the emergency and 7 months after, going on 6 months after my clients had been shut down. But that's not what we're asking you today. We are not challenging.
It's not your position that the emergency has ended, is it?
For purposes of today's, it depends on how you define emergency. The healthcare crisis, the healthcare need has not ended. Has the justification for the governor promulgating the healthcare response for going on 7 months now, is that still an emergency? The General Assembly and the Council of State have repeatedly asked the governor to allow them to do their job in response to this crisis. And the governor has repeatedly vetoed that. Now, I think that is a lane argument. I think that is a factor as to reasonableness, and courts quite often look at, to Justice Newby's earlier point, who is promulgating these rules. We give the greatest deference to the General Assembly promulgating laws acting in their lanes, and courts tend to give less to executive,
Well, here the legislature gave the emergency authority to the governor by delegation.
Yes, Your
And
Honor.
so you have,
Yes, they have given that. We're not asking the court to address that today. What we're asking
is your argument asking us to include in our calculus or the trial court's calculus how severe we think an otherwise properly declared emergency actually is?
No, I don't think so. I think this is a much simpler case. All this court has to say is that if any governor comes into the economy and starts closing down businesses under a state of emergency and starts picking winners and losers and shuts them down for months at a time, he has to be able to give a rational explanation, and it needs to be reasonably implemented. So even if they came forward and rationally tied my client's operations pursuant to their safety standards to be in an increased risk compared to other businesses, this court would still have to say, under the circumstances that surround us, is it reasonable to shut down these businesses and prevent them from earning their livelihood for 6 months? A total deprivation.
well, if the emergency is continuing, how does that take into account the additional authority and deference that the legislature gave to the governor under the Emergency Act?
The deference.
I mean, and when do you decide how long is too long if the emergency is still ongoing?
Well, that is the role of constitutional review. We see time and time again. We see it in there's several cases that have been decided in the last several weeks. Well, actually more than several weeks. So the Berean Baptist Church versus Cooper, Maryville Baptist Church versus Bashir, Robinson versus the Attorney General of the 11th Circuit, the Bashir out of the 6th Circuit. And you see two recurring themes, and we see this continuously in this court's jurisprudence and otherwise. If you deprive a fundamental right for a prolonged period of time, and by anybody's definition, 5.5 months is a prolonged period of time to have a fundamental right deprived. And if it's a total deprivation, this court's precedent says very clearly you have to have a very good reason for this level of deprivation. If we were standing before you 16 days after...
Are you saying that having an emergency declaration is not a good reason? And if it is a good reason, it sounds like you're saying that at some point the court just has to say, well, emergency or not, we're just going to say you can't have emergency measures anymore because it's been going on too long.
Well, the longer the deprivation goes on, the higher this court scrutiny must be. If the deprivation, the answer you...
With respect to the role of the courts, are you asking the court to just decide at some point that the emergency has ended? Or
no, what we're asking you to do is to ask the governor harder questions the longer the deprivation goes. Why are brewery tap rooms with people in close proximity drinking alcohol without face masks allowed to operate, but bowling lanes with every other...
Why is it that a policy issue addressed to the discretion of the governor in the situation of an emergency?
Because fundamental rights such as equal protection and fruit of labors, Article 1, Section 1 of this Constitution, do not exist at the sole discretion of any one man. It is this court's duty, and we would respectfully suggest sacred duty, to protect those rights. It's not something that's merely addressed at the ballot box.
Mr. Biller, to follow up on that question a second, I think you agreed earlier that the court's order focused on bowling centers and only bowling centers. Is the inquiry that you suggest should be undertaken in this set of circumstances, does it take into consideration economy-wide considerations, or does it have to be done on an industry-by-industry basis? In other words, is the governor entitled to take into consideration the effect of relaxing restrictions on one business type upon other business types, or to consider in some way the societal value, in his or her opinion, of those businesses, or does everything have to be done on an individual industry by industry basis?
Well, I think it needs to be done in an individual basis. And I think the governor has done that with regard to indoor restaurants. He said, well, I want to keep restaurants open. And here's my justification for keeping them open and closing bowling lanes. And then this court can decide under the circumstances if that's reasonable. The beauty of Poor Richards is it gives courts flexibilities to address the true facts in front of it. It's not binary. It's not lockstep. But when the governor makes decisions, those picks winners and losers, there has to be a rational basis for why some are picked as the winners and losers. And then the implementation of that has to be reasonable. And we see in all areas of constitutional jurisprudence, the reasonableness of constitutional deprivations changes by 1, the degree of the deprivation, and 2, the duration of time.
Mr. Miller. Going back to Justice Newby's question with us to Mr. Park about similarly situated businesses, what business or businesses do you contend are similarly situated to bowling centers in terms of the risk of spread?
Well, I think the risk of spread is much higher in brewery tap rooms, in tattoo parlors where people are in close proximity, punching needles into each other, in indoor overnight camps where people are playing activities in close quarters for overnight, which I would assume to be is at least 12 hours. There's 3, Your Honor.
And just to follow up to my earlier question, I think you faced another question, you didn't really get to answer it, but yes or no, but for these procedural safeguards that your clients offered to impose, would you concede that the governor has the constitutional authority to continue the closure of bowling alleys at this point in the pandemic? No, and that is our second claim that as applied, he's relying on GS General Statute 166A-1930 subparen C. And as we've argued in these papers and set forth in much greater detail at the trial court, as the governor is applying that statute, we think it's a gross violation of the North Carolina Constitution. Your Honor, I see I have 30 seconds. I have about 90 seconds for closing remarks, if you will indulge me.
You may.
Thank you. While the circumstances in this pandemic are unique in many ways, the issues of this case presents are not. Our system of constitutional liberty did away with the system that the rights of the individual must always yield to the common goods or the assertions of an elected leader. Even so, our nation's record of respect for such freedoms has been far from perfect. Not long ago, our nation faced the threat, not of a pandemic, but of a foreign invasion. Exigent circumstances. After December 7th, 1941, most of America's Pacific Fleet lay at the bottom of Pearl Harbor. Thousands were dead. There were fears of a Japanese invasion of the West Coast. President Franklin Roosevelt, acting consistent with an act of Congress, issued his executive order aimed at rooting out disloyalty among our fellow Americans of Japanese ancestry. Fred Korematsu was one of them. In a now infamous decision, our Supreme Court rejected his cry for freedom. Justice Hugo Black explained, similar to the arguments we hear today, we cannot say that the war-making branches of the government did not have ground for believing that in a critical hour, such persons could not readily be isolated and separately dealt with, and constituted a menace to the national defense and safety, which demanded that prompt and adequate measures be taken to guard against it. Korematsu was a low point in our constitutional history.
Mr. Biller, I thought you were sort of wrapping up. You were well above the 190 seconds, I think is what you asked for. Thank you very much. I appreciate it. Mr. Park, rebuttal.
Thank you, Your Honor. I'd like to make 2 quick points, if I may. First, I think on the issue of the safety protocols, with all due respect, I think it's a huge red herring. The safety protocols that were proposed are the same measures that Secretary Cohen considered, her entire public health team considered. They consist of face masks, sanitation measures, social distancing measures. Those are the exact same safety protocols.
Mr. Park, where is that in the record?
So if you look at Secretary Cohen's affidavit, she discusses sanitation protocols. She discusses why face masks can and cannot be used in certain settings. the entire premise, she does not say, I considered the Bowling Association safety protocols, but all of the factors that were considered in setting the phase 2 policies and in Secretary Cohen's declaration were the exact same measures that were proposed here. But on the broader legal point, it cannot be the case, especially under rational basis review with additional emergency deference, that if any regulated entity comes to a court and says, here is my alternative public health regulation that I like better, please enter it into the court, enter it through a court order, that becomes the law. That is not how rational basis review works. It's whether the regulation in question advances the government's interests. On the second issue, real quick, is on the nature of this emergency. I agree there are very difficult questions about when does an emergency end, about how deference is modulated based on the length of time. But here, since we filed our opening brief in this case, barely a month ago, 45,000 Americans have died from this disease. We are currently in an acute emergency. The evaluation is ongoing. I think Mr. Biller's comparisons to war are very apt. That number of people is about the same amount of people that died in battle in Vietnam over a decade. If deference does proceed over time as the emergency subsides, this is not the moment for that to occur. And related to the aspect of bowling alleys, I think there are factual questions about who bowls. In Mr. Biller's demand letter to the governor, and this is on page 75 of the record, he mentioned senior leagues as one reason why bowling alleys should open. That is a high risk category. But even if everyone who did bowl were in low risk categories, as the Seventh Circuit said in the Pritzker case, and that involved fundamental rights, First Amendment right to speech and assembly, it's not just about the people who go to a meeting or protest. It's about every single person that they interact with, because we are in the context of asymptomatic spread. And that's something that at the very beginning of the pandemic, we were still learning, that this spreads very easily on people who aren't exhibiting symptoms at this time. And so I guess if I may, I know there might be questions. I'm happy to answer questions. I would just say this. It is true that Governor Cooper has embraced a more cautious approach to reopening economic activity, and that he has, as a policy matter, determined that public health is his top priority. And there are natural experiments throughout this country where different governors have taken a different approach. Georgia is a great comparison. Around the same time that Mr. Biller filed his complaint, and many of these complaints were filed, the governor of Georgia decided to do what they had asked, to disregard public health experts and to allow high-risk venues like bowling alleys, bars to reopen. And what we saw over the next couple of months were thousands of additional deaths beyond what our state was experiencing. And the overarching question here really is, who gets to make that decision? What is rational in terms of the balance between protecting against additional spread of this violence and economic freedoms and economic activity? And I would submit that it's the governor, because these are inherently discretionary decisions. And I don't think that courts are institutionally well suited to be making decisions of this kind. Thank you, Your Honors.
Thank you, Mr. Parker, Mr. Biller. Madam Clerk, would you recess us? I think you are muted.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is in recess. God save the state and this honorable court.